Hello, everybody. I welcome you all to yet another episode of SoftCover, which is an exclusive platform for online release of non-fiction books on ThePrint's YouTube channel. Our guest for today is not new to this show. Exactly a year ago, we had interviewed him for his first book titled Liberty After Freedom. Yes, we have with us Supreme Court advocate and author Rohan J Alva, whose second book, A Constitution to Keep, would be released today. Welcome, Rohan. Before we move ahead, to talk about your book, let me first unveil it. I have the book with me. This is the book, A Constitution to Keep, Sedition and Free Speech in Modern India, Rohan J Alva, and it is published by HarperCollins. Many, many congratulations, Rohan, for your second book.
Thank you so much, and great to be back here.
Yeah. So, Rohan, this is your second book, and it is, in terms of the narrative style and in terms of, I think, the topic which you've chosen, it's quite similar to the one which you wrote in the past as well. And it's on a topic which is at the intersection of history and law, the two subjects which you have studied and are now, pursuing as your career as well. So, Rohan, while in your first book, you actually dissected the history of Article 21, which has since independence evolved as the most important provision of the Constitution. Your second book touches upon a very highly contentious penal provision, which is Section 124A of the Indian Penal Code, or commonly called the Sedition Law, and how it impacts free speech, more specifically political speech, which is antithetical to the principles of democracy. The book also traces the history of free speech provision in the Constitution. Now, for both your books, you delved deeply into the Constituent Assembly debates as well as catena of court verdicts, particularly the Supreme Court. As for Article 21, Rohan, courts have over the years expanded its ambit. Do you feel, or did you ever feel while doing your research for your second book, that, constitutional and judicial history has to some extent been unfair to the Indian citizen in terms of free speech? Why I say so is because, all of us know that sedition became part of the penal law during the British regime. It was a tool that was used by the British government at that point of time to stifle all forms of criticism against the then government. However, our very own political leaders have retained it in the statute book, despite some of them arguing against it, agitating against it. Why?
So, firstly, thank you for having me, and thank you for presenting the book. This, in fact, when I began writing this book, I realized that this is one legal provision, and it's very interesting that one legal provision can become the point of departure to understand the political history of our country, the social history of our country, the legal history of the Constitution, and finally, how this provision was a battleground between the nationalist leaders and the British government till 1947. So what I thought I would do is present this particular topic in three parts, because I've really tried to write it and make it accessible to the lay reader, because it's really complicated legalese.
I agree.
Complicated constitutional law, decisions after decision, judgments after judgments. And for those who are not familiar with it, it's very difficult to navigate. So the method in which I approached this topic was to really write it in an accessible manner. And that's why what I did in the book is that I divided it into three phases. In the first phase, I tried to cover from the 1800s till 1947 to really understand how this law was created, why was it made a part of the penal code, how was it used, how did it become a law which was the choice, which was the best choice for the government to suppress the voices of the nationalist leaders. In the second, I try and cover the small period between 1947 and 1951, which is essentially the time period within which the Constitution actually comes into force, up till the First Amendment, which is one of the most transformative amendments that took place where free speech was amended, land reform laws was sought to be saved by new articles. And in the third part of the book, I try and cover from 1951 up till today, and making a thematic discussion of some of the important areas of constitutional law which are necessary for analyzing this particular provision, to try and understand how the constitution itself can become a tool to try and understand and engage with this provision. And very interestingly, what I found is that there were several controversies that rage not only today, but in fact, the controversies which rage about sedition today, in fact, raged in the 1830s. And none other than the functionaries in the British government tried to point it out. And the principal argument or the critique was that this law will really mean that the freedom of the press will become very difficult to maintain. The free press, as it were, will find it very difficult to survive. That was the principal critique, and that was something that was uniformly and universally articulated right up till the 1950s. The second very interesting thing, I think, as a person anyone who wants to engage with this topic, will see that there were ups and downs in terms of how this particular law was implemented. So what I divided, I say that one section of the cases, in fact, the majority of the cases, up till 1947, like Tilak's trial, Gandhi's trial, show us how this law was essentially used to preserve British sovereignty. But there was also a line of cases which said that political speech should be free, and that political critique of political matters is something that can't be treated as an offense within this particular provision. So I think the pull and push of events that were occurring in India had an influence on which way the court would judge it. And then finally, this particular provision, which is very interesting, and this is something that really should be known, was one of the most intensely debated legal provisions in the Constituent Assembly. Because you're really making a constitution for a new nation. Why would you want to debate this provision? And as I said, the reason that this particular provision was discussed by so many in the assembly is because it was this law which had really been something that they had to deal with for several years, several decades, in fact. Many of them were very familiar with it in a very intense sense. They were prosecuted under it. So their principal idea was, how should free speech be formulated, and whether or not sedition should exist as a law when the freedom of speech is now being guaranteed as a fundamental right in the Constitution.
Yeah. Okay. So, right. So, in fact, I would like to add over here, I mean, you've, of course, explained it for our viewers, how you have divided the book into three parts, tracing the history of free speech and the sedition law. I must compliment you for doing this, because it's a very technical subject which you have dealt with. And as I noticed in your earlier book, in this book as well, the way you have traced India's whole history vis-a-vis the history of this penal provision, the way you have interplayed the two together, I think it's a fantastic job and very well done, because this kind of narrative style can actually generate a lot of interest in the readers to know exactly how and why was sedition law brought into force. But Rohan, while talking about the Constituent Assembly debates, I mean, after reading the book, of course, I realized that, there were this entire provision was intensely debated in the Constituent Assembly. And in fact, you refer to our first Prime Minister Jawaharlal Nehru's speech as well. So from what I gather, the debates show that, I mean, including the sedition law as a reasonable restriction on free speech was not really favored. But then why do you think that over the years, the governments of the day, irrespective of the party in power, never made any attempt to remove it from the penal code? Do you think the executive, whether it was the initial Congress government or whether it was the next government by the Janata Party, so do you think the executive let the status quo prevail for its own convenience?
So the thing is that I wanted to analyze this from a much larger perspective, because the reality is that this law has existed now since 1950 and it has been used. But I tried to take a different approach in the book. And this really was to try and understand step by step what happened after the Constitution came into existence. So the first thing that happened was that when the free speech right was to be formulated, now you're giving a fundamental right to citizens. Now, there are two important interests which sort of intersect here. One is that the state must know, and that was not disputed at all. The state must know when it can curb free speech. And the second was the citizen must know how they can assert their fundamental right. So as far as the ability of the state to restrict speech was concerned, there was a departure that the Constituent Assembly adopted. So if we read Article 19, which contains many of the civil rights, the freedom of speech, the freedom of association, the freedom of choosing your employment, etc., there was a departure, because what the assembly said was that, look, if we are dealing with free speech, which is one of the most important fundamental rights, we should not have a provision which is an open-ended provision, which doesn't really tell us when the state can restrict the right. So what we'll do is, we will articulate the specific grounds on which you can restrict the rights. Now, this is very important because this is unlike many other constitutions. So public order is the security of India. Sorry, public order was not included, but the security of India, etc., was now made a part of 19.2. So this is the first part. So when this happened, there was a very interesting up and down that happened. So in 1947, Sardar Vallabhbhai Patel played an exceptionally important role as a statesman. And he said that as the preliminary draft of fundamental rights, I'm not going to propose sedition as a curb on free speech.
Yes.
So out went sedition. Then when the drafting committee began to formulate the draft constitution, which had to be debated, somehow sedition was reintroduced. So sedition now became a curb on free speech. When this went to the assembly, there was a very intense debate. And the result of that was that ultimately the assembly agreed that we will remove sedition as a curb on free speech. Now, the difficulty was that once you have removed something as a curb, and the Constituent Assembly has said yes to it, bringing it back will become very difficult. So until 1947, it was quite evident that sedition is not going to be a curb on free speech. And almost immediately this was recognized. There were a few decisions in the 1950s, which very clearly said that sedition is unconstitutional because it is not saved by the provision in the Constitution which articulates the grounds on which free speech can be curbed. So this is the first part. Now, in 1951 comes the First Amendment. Now, my theory is that the First Amendment did not revive sedition as a curb on free speech.
Yeah.
But it's slightly complicated, because what happened was that in 1951, by the First Amendment, public order was introduced as a ground to curb free speech. So many thought that now that you have introduced public order, what will happen to sedition? Now, the answer was that sedition has been struck down, and the First Amendment is a very important provision relating to free speech. What it said is that, look, we are now bringing in a new Article 19.2, the provision dealing with the curbs on free speech. We are introducing new grounds, for example, public order. But if a law has been struck down between 1950 and 51, that law will not automatically revive unless and until it can be shown that the particular law is consistent with the new Article 19.2. So in other words, there was a condition that the First Amendment imposed, that the revival of these laws, which were invalidated, including Section 124A, it would not revive unless it was shown that it was consistent with the new Article 19.2. Now, my argument is that even after the First Amendment, sedition remained unconstitutional.
Right.
And there was perhaps that was at play, that it was not specifically repealed because the understanding was that Section 124A has been struck down. So, for example, one of the most famous judgments which any law student when they enter law school are taught is Romesh Thapar and Brij Bhushan's case.
Yes.
Two different laws which were considered insidious restriction on the freedom of the press were struck down by the Supreme Court. Justice Fazal Ali dissented. Now, my argument is that even those laws were not revived by the new Article 19.2. So even though laws were struck down between 1950 and 51 for violating free speech, including sedition, the argument was that if you can show that it revives under the new Article 19.2, under the First Amendment, only then will the law be deemed to be constitutional. Now, this is something which is very interesting, because the First Amendment also contained provisions dealing with land reform. Now, the Patna High Court had struck down the land reform laws, But in respect of land reform laws, a new Article 31B and a ninth schedule were created by the First Amendment, which said that these laws are shielded, they cannot be reviewed. If they have been struck down, they revive even though they may violate fundamental rights. So this was the important difference. If a law violated free speech rights between 50 and 51, and if it was struck down, it would revive only conditionally. The condition was that it had to be a reasonable restriction, and the word reasonable was introduced by the First Amendment, which in my opinion is a constitutional revolution, which is quite overlooked. And it must also trace its provenance to the new grounds on which free speech can be curbed. But the same was not adopted for land reform laws. The land reform laws automatically revived, even though they may be unconstitutional and they may violate fundamental rights. So this is a very important point that the First Amendment made, that free speech laws still had to be analyzed and had to be scrutinized quite rigorously to see whether they were saved by the Constitution. And it culminates in the 1962 judgment, which I have examined in some detail, which ultimately upheld sedition. But in my understanding of the judgment, this particular analysis was not undertaken by the court. Unfortunately, they didn't look at the true scope of the First Amendment. What was the real intent behind the First Amendment? Was it supposed to revive laws automatically? In fact, was public order in new Article 19.2, was this new ground of public order did it even have sedition in mind when it was introduced?
Rohan, in fact, yeah, I wanted you to kind of, give us a brief insight about the case as well, because it's a much talked about judgment by the Supreme Court. And could you also explain how it really changed the free speech landscape in our country?
Yes.
Also this judgment, I think, broke several settled legal questions. What does it really reflect about our judiciary as well? So there are two questions in this one, broader question. First of all, in the sense about the judgment, what is your insight about it? And secondly, what does it really speak about our judicial setup, our judiciary?
So my training as a historian before I was a lawyer has taught me that if you look at something, you're really not able to understand what it actually means if you don't look at it in its historical context, because it throws a lot of light. So similarly, if one were to just read the judgment, you would just sort of read it and figure out that this is the line of reasoning that inspired the Supreme Court to uphold Section 124. But when it is seen in its historical background and the circumstances which led to the challenge in 1962, things appear a little different. And I'll just give a few examples.
Yeah.
So the example that I just gave is that within Parliament, which is the provisional Parliament which debated the First Amendment, which ultimately came into force in June 1951, there was this very important debate as to whether the new ground of public order that is now being introduced as a new ground on which free speech can be curbed, does it have any relation to sedition or not? Speech after speech said that it does not. In fact, there was another provision which said that laws relating to free speech that have been struck down will revive, but very mysteriously, that provision never actually entered the Constitution. And Justice Hidayatullah and Golaknath's case actually said that this provision somehow just disappeared. It was passed by the First Amendment, but where it's gone, no one really knows. It's not really discussed because of the new 19.2. So this was one very interesting thing I found out only because of the historical story of free speech. There was this mysterious provision, Section 3.2. Anyone who's interested can look at it, of the First Amendment bill, which was passed, but somehow it didn't really translate. It's never been used. And this Justice Hidayatullah pointed this out. So there was this approach that had to be adopted as far as free speech was concerned. Land reforms was a separate question. So as far as the First Amendment, so if our argument is that the First Amendment to the Constitution revives sedition, my conclusion is that it is tenuous at best, and it's in fact unsustainable. The First Amendment did not revive sedition. Okay. And that's the reason why the debates actually occurred, where speeches were made as to why public order is not meant to save sedition. That's the first thing. Secondly is that between the 1950s and the 1960s, and this is the run-up to 1962, judgment after judgment, and these are constitution benches, which is 5 judges. This is a constitution bench, in judgment after judgment, they gave thumping judgments in favor of free speech and the freedom of the press. So Sakal Papers, for example, is an exceptionally well-reasoned judgment on the freedom of the press. Ram Manohar Lohiya's case by Justice Subbarao, once again, an important judgment. And there were several judgments which asserted the idea that there were essentially three important facets of Article 19(1)A, which is free speech. The first, which is what I really emphasize in the book. So my book is really part about sedition, but is much more of a manifesto about really how political speech, where an individual wants to comment on a matter of urgent political importance, how that's to be protected by the Constitution. So the first, and this was universally accepted, is that political speech lies at the core of the fundamental right to free speech. Right. And you can relate this back to the debates. Sardar Patel's speech, K.M. Munchi's speech, Pandit Thakurdas Bhargava's speech, anyone, you pick up any speech, everyone agreed that the principal purpose of the free speech right is to protect and enhance political speech. Everything else may be of slightly secondary importance, like commercial speech, freedom of speech in other spheres. But political speech and side by side, the free press were core rights guaranteed by the free speech right of the Constitution. So that's the first point. The second and equally important is that if political speech is something that is protected by the Constitution, then a restriction on that particular right has to be viewed with extreme suspicion. And that is what happened in all these judgments where they were struck down. So instead of, for example, in Sakal Papers, instead of directly curbing the freedom of the press, you adopted a roundabout route by saying we want to regulate the commercial activities of the press, which ultimately would mean that the freedom of the press would be affected. That was struck down for violating the freedom of speech. And the third is that there was this confusion, I think, in the Supreme Court judgment of 1962 as to how it must deal with these important judgments on sedition, which were handed down just before India became independent. So in 1942, the federal court, speaking through Chief Justice Guire, gave this very important judgment where they said political speech is important. Those who wish to engage in the political sphere must have the freedom to do so. So therefore, a political speech cannot be treated as sedition. You cannot judge speech by the form that it has, but the content, etc. And that judgment essentially said that a conviction under a rule which was very similar to the law on sedition was not sustainable. But that judgment somehow was not really fully applied. And this is really something how history was sort of understood in a different manner. And ultimately, the court concluded that although 19(1)A and 19(2), the freedom of speech and the curbs on free speech, were transformed in 1951. In the opinion of the court, the transformation, in fact, was a complete answer to say that sedition is actually saved by the Constitution. But this entire historical analysis, the run-up from the 1800s till 1947, the details of the debate that occurred on the First Amendment, how was the First Amendment, in fact, understood? There was a High Court judgment in 1958 of the Allahabad High Court, which actually said that the First Amendment debates very clearly show that apart from everything else, sedition is not saved by the First Amendment to the Constitution. That was not really properly appreciated. There were a large number of judgments which asserted the idea that free speech is a very important right. Political speech is part of the core of free speech rights. But all of this was sort of not properly appreciated. And I think that's why ultimately it was upheld.
But you know, Rohan, that's what has really intrigued me after I read your book. They're the same leaders who at one point of time agitated against Section 124A and advocated, you know, the need for free speech as well during the British era. For some strange reason, they never made an attempt to, you know, to do away with this provision. Why? I mean, since you have done this research work, you've studied history also. What do you actually think weighed in their minds to let this provision continue in the statute books?
So the way I wanted to approach this problem, a problem regarding this constitutional problem that sedition raises, I wanted to see it in different perspectives. So the first perspective that I wanted to see it is the historical perspective.
Yeah.
Then when I saw it in the international perspective, that threw important light. So I'll give you one example. James Stephen is considered the father of many of the important laws that are in force even today. Now, he is the person who actually advocated that sedition should become a part of the Indian Penal Code.
Yeah.
In fact, Macaulay came to India in 1834. In 1837, they submitted a report. Macaulay's penal code contained a clause 113, which was similar to section 124A, but it somehow slipped through the gaps and it wasn't really part of the IPC, which came into force in 1860. And then James Stephen in 1870 brought it back. Now, he wrote a very important book on criminal law, and he made a very interesting observation. He said that if you have a system of if you have a system, any system, where there is a ruler and a subject, then it is obvious that there has to be an offense such as sedition. Okay. Because you're now dealing with a ruler and a subject. So subject can never question the ruler. But he said, and this is very important, but he said, if you are dealing with a democracy, if you are dealing with a system of government where people elect their representative government, that the government is in fact the agent of the people, then it is a contradiction in terms to have an offense like sedition, because what you're doing is that the agent of the people is now suppressing the voice of the people. Yes. So this is right from the horse's mouth.
Yeah.
Something similar happened in the United States. There was an experiment with bringing sedition, and finally it was done away with. There was enormous criticism of it, and today it's considered one of the black marks in American history, where sedition was brought in as an offense. Now, if it's seen in an international perspective, that particular part of the freedom of speech in relation to self-government, in relation to people articulating political speech, in relation to people using the freedom of speech to engage with the government in sort of a form of discourse where there is a discussion of their state of being, where they are able to understand what is going on and they are able to articulate a counterpoint, is something that was implicit, in fact, in 1918. It was so implicit, there was no need to say it so clearly, because that was the central idea or the central motivating factor for free speech. So I think that's one very important point when we look at sedition, that this entire context and background, I think, leads to a very important conclusion, that political speech, and particularly the ability of the people to engage with their state of being, is something that is central to 1918. Now, the Supreme Court, in fact, made this observation when it stayed the operation of Section 124A. In fact, it sort of touched upon these acts. It's a brief order because it's just a stay order where it suspended the operation, but it touched upon these factors. And it said that on an analysis of this factor, we are persuaded that there is good ground made out to, in fact, suspend the operation of Section 120. So I think what was happening in the world from the 1800s right up to the middle of the 20th century was sort of taken note of by the court in 2022 when it suspended the operation of Section 124A.
But, coming to this order also, Rohan, the Supreme Court took almost a year to actually pass an interim order on a batch of petitions challenging the constitutional validity of sedition law. And it's been almost 8 to 9 months now, and we haven't seen even a single hearing in the case. We don't know when the matters would be taken up. And, I had actually asked you earlier also, the fact that Kedarnath judgment kind of broke several settled legal questions. So what does it really say about our judicial setup? Has our judiciary kind of been kind enough, to let free speech be as it was envisaged by our constitution makers? So do you think judiciary has to some extent played any role or not in protecting free speech?
Yeah, so I think, again, if you see before from the 1950s, and then throughout in fact, I've highlighted this in a book, 1960s, 1970s, 1980s, 1990s, 2000. So if I take the entire spectrum, starting from Romesh Thapar's case in 1950 up till the famous Shreya Singhal judgment.
Yes.
And then after that, a few more judgments which were given in the context of free speech. I think the bulk of the judgments, in fact, almost all of it, leans in favor of a much more robust free speech architecture being created in India. Okay. So that's the first point. So even if I were to sort of take Kedarnath and put it aside, the bulk of the decisions, in fact, over the last 60 years, will help me to say that, really speaking, free speech is supposed to be a robust right. The second important thing that these judgments say is that you cannot curb free speech. For example, if you're curbing political speech, that's what was articulated in Romesh Thapar right up till Shreya Singhal in 2015. You cannot articulate, you cannot restrict political speech, and you cannot adopt indirect means of curbing it, which is again a very important principle when we are speaking of free speech. And finally, I think what is really essential is that this entire backdrop of understanding sedition has to be seen in the historical perspective. I'll give a very interesting example. I was able to pull out archival material from the British Library. And when I pulled it out, I found this transcript of arguments by Asquith in Tilak's appeal in the Privy Council. So when he was convicted by the Bombay High Court, he took his appeal to the Privy Council. Now, Asquith's argument runs very small font. I think it must be size 8 or size 7. And it runs into about 25 odd pages. So he really labored on the point and he made brilliant arguments which are relevant even today. For example, he said that if I say something, that's what happened to Tilak. If he says something that you deem sedition, then you cannot divorce it from the way in which it is understood by the people who receive the speech. So you can't take a foreigner's point of view and say that this kind of speech I do not tolerate when it is understood in a different manner by those who received it. Secondly, he said that what matters is not the subject of the speech, but its object.
Right.
So the object is, and this is what I say in the book, if there is going to be an imminently inevitable threat to the security of India, that is something that can be regulated. But if it is only about political speech and engaging on a particular issue which a person feels is important, then that is squarely protected by Article 19. So I think all of these events, which because there's a long history, nearly 150 years, is very crucial for us to understand how do we really engage with it. Because if you read the bare text of the law, it really doesn't inform us. It doesn't really help us. If you only read the fundamental right to free speech in isolation, you're not able to sort of fully or comprehensively analyze how exactly do I use the freedom of speech to sort of make an argument that sedition is unconstitutional. Only when it's seen in a historical, political, jurisprudential perspective will a clearer picture emerge of how really we can substantively engage with this particular issue.
Let's come back to the role played by our government, So you have mentioned about another law called UPA, which is an anti-terror law. So while we had free speech and it continues to be there in the penal provisions, the government comes up with another law, which is UPA, which contains almost similar, one of the sections in UPA is exactly similar to that of sedition. And then we also had one of the provisions under the Information Technology Act, which is Section 66A, which was again quite similarly worded as Section 124A. Of course, Section 66A was finally struck down by the Supreme Court, but UPA continues to be there. And so, of course, you've mentioned this in your book, that simply doing away with 124A is not sufficient.
Yes.
So how do you see, what does this really say about the government's role in this entire, in terms of the free speech construction, in terms of the free speech architecture? Of course, now, as you mentioned, the judiciary has advocated in favor of it, except for the Kedarnath judgment, which can be, said to be an aberration. But then what about the government? Why is it why did it think of bringing yet another law that, constricted free speech further?
Right. So I think that was because there was yet another amendment to the Constitution. And essentially, there was a need where a new ground was introduced in 1902, which is really the basis on which the UAPA law was made. But as I've said in the book that, and once again, these UAPA petitions are also pending.
Yeah.
But as I've said in the book, I've said that essentially everything that you can use as a point of critique for the sedition provision can equally apply for these provisions, although there is some difference in the language, there's some difference in the words. But ultimately, the question, which is what I also explore, is that let us assume that after UAPA, there's yet another law which is similar to sedition. What is going to be the answer to it? The answer, in my opinion, is that there are three important ways which the Constitution itself tells us how free speech is to be treated. So it's not something outside, it's within the Constitution. The first and the most important is that there is this one word in 19.2, which is often, it's not really appreciated, which is the word reasonable. Came in by the First Amendment. Now, very interestingly, reasonable was not part of the original constitution. So the arguments were that we must bring in reasonable, otherwise you can just make any law to curb speech. It may be unreasonable, irrational. That part of the law cannot be analyzed as long as I can trace it to 19.2, which is the grounds on which free speech can be curbed. Now, the word reasonable has been interpreted in two important ways. The first is that any law affecting free speech has to have what is called in India a proximate relation to the ground in 19.2, and what is abroad called has to have an imminently inevitable threat to that particular interest. So if I'm saying that something is for public order, the test articulated by the Supreme Court, and the most famous judgment is of Justice Subbarao, says that it must have a proximate link to that particular interest, which is the basis for the law in question. So that's the first one. The second is that only that part of action can be regulated, which really has an imminent threat on, for example, the security of India. So if you are able to show that an action is going to have an imminently inevitable threat, and this is the most proportionate manner in which it can be dealt with, then perhaps the law may pass muster. But if it is shown that there are other ways of restricting the right, then the free speech right has to be safeguarded. And finally, if it is political speech in question, the method of analysis is that the political speech, the interest has to be that political speech has to in fact be promoted and safeguarded. And it has to be seen whether that particular act is harming political speech or is creating a restriction which really does not affect the full play of the right of a citizen to engage in political speech. I think that's the way to approach it, because because these laws, 1962, etc., in Kedarnath and thereafter these other laws which came, there has to be a method by which there has to be some sort of rational basis. We have to have the tools to understand that if we are confronted with this law, what's the step-by-step basis with which we can actually engage it and critique it. I think that's really an important thing that I've tried to highlight in the book.
Yeah. So before I end this conversation, Rohan, I have one question which I want to put across to you. This is a question which is often asked by those who support the sedition law, who want the sedition law to continue. Now, it is said, that the state's primary responsibility is to protect the life and liberty of the citizens. But if the state is unable to protect itself, then how can it protect the life and liberty of the other citizens? So the supporters of sedition law argue that laws or penal provisions like sedition are there to protect the state's rights, and that doing away with this law will result in smaller terror groups flourishing. They also cite data to say that in the last 75 years, not much prosecution has happened under sedition, and the numbers are very low. So now the question which actually confronts us is whether the law is a problem, whether the wording of the law is a problem, or whether its implementation part is a problem. What do you have to say on this?
So I looked at it from a slightly different perspective. I tried to see, or that's what I really explored, what does it actually attack? What is it really relating to? And it relates to criticism of political affairs. Now, this is something, again, it has deep echoes in history. Every time the law on sedition was critiqued, the answer was, look, there is an explanation. Originally, there was one explanation, then by an amendment, several new explanations came in which we have said, look, you can have political critique, you can say what you feel like, so long as you do not excite disaffection.
Yes.
So the first problem with this, and this is what Tilak highlighted, and that's why Tilak's trial is so important. What he said is that whether or not I say something and whether it has some effect or consequences immaterial for my prosecution. So what it really does is that it stops me from articulating what I truly feel about my state of being and engaging with it at a substantive level. That's what it actually stifles. It doesn't really relate or doesn't concern itself with the consequences of what I've said. The second is that if it is unconcerned with consequences, which is that purely exciting or saying something which is deemed to excite disaffection and made a crime, then almost immediately it's evident that we are not dealing with what will happen as a result of it. So, for example, if nothing happens as a result of it, or something does happen as a result of it, is treated as virtually the same offense. And the
Yeah.
third is that the state does have a legitimate right. This was never in dispute. This was not in dispute in the Constituent Assembly. It was not in dispute in the First Amendment. It's not been disputed at all. The state does have a legitimate right to protect the security of the country. It does have a right to protect the sovereignty of India. It does have that right. Under 92 is expressly given. But if it is given, it must relate to those class of actions which actually have that effect. So if a person is using political speech, if a person is simply engaging with a political matter, is just trying to articulate a premise and is just trying to start a debate, is sort of become an informed citizen, is trying to hear a counter view, that is not the same as someone who's trying to actively use actions, is actually collecting individuals, trying to destabilize. That those are not the same. So I make that point in the book that that second set of actions are probably something that the state can deal with. But everything before that, when you're dealing with the discussion and the ideas of matters which you think are important, is in the realm of discussion and ideas, essentially either to bring about a transformation, put forth a counterpoint of view, to bring new information, etc. That is something that is guaranteed by the Constitution. That's something that's really we don't need to labor on it. It's in fact guaranteed there, and there's quite a bit of authority. I've in fact cited several authorities in the footnotes. What I try and say is that whichever way we approach the free speech right, this part is something that is sacrosanct as far as fundamental rights are concerned.
Well, thank you so much, Rohan. I'm afraid we just have this much of time with us. Thank you once again for joining us with for this wonderful and insightful discussion on a subject which is highly debatable now. And many congratulations to you for your second book. And I wish you the best for its success.
Thanks
Thank
a
you
lot.
so much.
Thank you for having me.
Thanks a lot, Rohan. Bye-bye.